learner, welcome to Transnational Competition Law course. And today I am going to deliver the my lecture on enforcement of extraterritorial application of competition law in developing countries in continuation with our discussion on the topic of extraterritorial application of competition law in reference to United States, in reference to European Union, in reference to the theories of extraterritorial application of competition law in European Union, in reference to extra principles of extraterritorial application of competition law in European Union, we will now reasonably and logically switch over to the another lecture on the theme of enforcement of extraterritorial application of competition law in developing countries. Dear learner and viewers, we will begin as kind of a survey and we will try to see the conglomerates of all the countries at the global level, be that the first world, the second world, and the third world, or developed countries, developing countries, and underdeveloped countries, in fostering a kind of a competition law and policy regime which expressly recognizes extraterritorial application of competition law. We will begin with the competition law enforcement, and we will try to see that how competition law enforcement of extraterritorial jurisdiction is significant under the purview, ambit, and scope of domestic competition legislation. We will be also discussing and addressing transnational violations of competition law that causes significant economic harm globally and as well as in the domestic market of the developing countries. We will try to understand the competition law enforcement mechanism and its enabling provisions in developing countries to safeguard their domestic market and develop capacity in dealing with transnational business. We will try to gauge the fact that to what extent the competition law enforcement of extraterritorial jurisdiction has its acceptance and its indication and its usefulness in protecting domestic interest and inbound anti-competitive harms in the domestic market. We will be also surveying we will be also surveying that besides the acceptance of extraterritorial application of competition law in the domestic market, as to how developing countries have reported practical experiences with applying their competition law in an extraterritorial manner, specifically by reviewing offshore merger and amalgamations, restrictive trade practices, and cartelization as the major problem in the developing countries' enforcement of extraterritoriality. We will also be dwelling on the aspect that across developing countries, are there some significant regional blocs, such as the BRICS and others like that, which try to address very meaningfully the procedural rules and evidentiary values of any kind of a competition transactions in addressing cross-border anti-competitive conduct. We will be, in fact, investigating some of the competition cases by different jurisdictions and judicial fora, which has dwelled on the aspect of challenges in the enforcement of extraterritorial application of competition law. More specifically, we'll be taking note of the fact of procedural rules, the rules of evidence, the rules regarding the non compliance, besides the political pressures and other hindrance, hiccups, and hurdles in the enforcement regime. We will also goes on to record the very fact of transnational enforcement to see as how the collaborative effort and trust building can be one of the very viable mechanism for the enforcement of extraterritorial application of competition law in developing countries. Secondly, dear learner and viewer, we will be directly focusing on the point of what are the experiences of the enforcement of extraterritorial application of competition law in developing countries. Are these experiences are solid? Are these experiences are wise? Are these experiences have some kind of a salubrious provisions and have a pleasant note to augur further anti-competitive practices and forge and foster the competition across the global market. We'll be dealing in this part of the lecture precisely that what are the firms which happens to violate competition law and what is their sizable presence in the regional, domestic, regional, and international forum. We'll be precisely looking and pulling out the report of John M. Connor's brilliant essay on the point of the private international cartel, which he termed as PIC dataset, guide and summary statistics, which the learned author John M. Connor very meticulously collated and reflected very brilliantly encompassing 1990 to 2016 among all the developing countries. The study of John M. Connor is of seminal significance in realizing the enforcement experiences of extraterritorial application of competition law. The same document, Guide and Summary Statistics of 1990 to 2016, a survey of more than a quarter of century, reflects significantly the intrinsic cross-border transfer of wealth and makes a particular case and salient generalizations from the political economic perspective across all the developing countries. It also nicely dwell on the aspect of practical experiences from underreporting by the news outlet and its ultimate and penultimate enforcement against transnational competitive conduct. Having understood the major problems of the extraterritorial application of competition law in developing countries per se, and in reference to John M. Connor's study of the private international cartels dataset, we will be in a position to look at what are the relative experiences on the merger, and we will review that how across all the jurisdictions of the world, especially the developing countries, that initial experiences with extraterritorial jurisdiction tends to focus on the merger review, looking at from an investigatory perspective and anti-competitive effect of the offshore transaction. We will review the entire intricacies of the merger and conducting investigations at different jurisdictions of the developing countries through the catena of the cases and judicial pronouncements. Then we will be switching over to the experiences of enforcement of extraterritorial application of competition law in developing countries, taking 14 participating countries as a test case, which has involved restrictive agreement among multi-party conduct and cartel. Countries like Brazil, Chile, China, Cambodia, India, Kenya, Malaysia, Mexico, Pakistan, Peru, Russia, Russian Federation, Serbia, South Africa, and Turkey. These behavior and these trend and these tendencies are to be studied from the angle of American soda ash export cartel, while looking at how this case in two jurisdictions, at least in Indian jurisdictions and South African jurisdictions, have overplayed and underplayed the entire enforcement mechanism, and how the United States imposed criminal sanction for anti-competitive conduct in the United States market and transnational jurisdictions. We will also look at the judgment of American Soda Company, which is shortly known as ANSAC, and the American Soda Ash Export Cartel. We will be looking that case from a very dispassionate and critical angle to discern some of the concerns which is prevalent at the level of registered export cartel and investigation mechanism, and some of the jurisdictional issues which are cropped up in 1990 as reflected in the European Union's competition law and the Indian Supreme Court and the South African Court on this case. We will be looking at the ratio of Manufacturer Association of India versus American Natural Soda Ash Corporation 1998 from the Indian Supreme Court's lens. And then we will also look at Haridas Export versus All India Float Glass Manufacturer Association. In looking at how the Indian law, which was not having a transnational application provision, finally found its acceptance by the United States political pressure in terms of United States State Representative intervention, precisely on the ground of withdrawal of trade preferences and United States advocacy about equitable and reasonable market access to United States goods in India, and ultimately finding a place of Article 32 of the Competition Act by way of an amendment in 2003 to have an express verbis recognition of the extraterritorial jurisdiction in the Indian context. Dear learner, with these kind of a discussion and diametrics, we'll be referring to the effect doctrine and examine as to what extent the effect doctrine permeated in the United States antitrust competition law has been made applicable in the developing countries by a kind of innovation which can be called as the effect doctrine per se are not to be applicable, but when there is a deleterious effect, then this doctrine can well be suited to tailor the needs of the developing countries in matters of extraterritorial reach, and it was applied by the South African agencies as well as the Supreme Court of Appeal of South Africa in ANSAC case in 2008, leading to some substantial fine and sanction. We'll be referring to some of the example of South American countries, especially the practice of anti-competitive conduct from the standpoint of view of Mexico, and in reference to the two cases of ADM and Coiva active in the Mexican market in the breach of law, and how the Mexico happens to be very successful in the enforcement of extraterritorial application of competition law. We will also look at the Brazilian international conduct case of 1999 in relation to international vitamins cartelization and its action by the European Union and the United States to have some very practical insight in relation to the extraterritorial application of competition law in developing countries, more so by the Hoffman Law Roque Aventis case in 2007. In the North American countries, we'll be also discussing the Chilean response and the Chilean authorities' investigation of international refrigeration compressor cartel in Whirlpool case in 2012, wherein the Brazil and Chile was of the view that the 97% of the sales in the Chilean market was having a kind of a cartelization, and it affected the domestic market very adversely and had a very deleterious impact on their national jurisdiction. Then, with these discussion, we will be having a kind of a diversified opinion of not only India but South Africa, so African, Asian, American, European, and all other jurisdictions we have taken together to have a very holistic perspective about the notion of the enforcement of the extraterritorial application of competition law in developing countries. And the emphasis of my lecture, dear learner, will be on the aspect which is pragmatic, practical, and prognostic, that the practices and conventions of different countries